Chairperson Dr. W.D. Patriko, Dean Dr. Pratibha Mahanamayava, and my colleagues. My paper is an analysis of the jurisdiction, duties and powers of an industrial arbitrator in Sri Lanka. But the presentation has many slides, but I will skip some slides. Actually, when it comes to this presentation, it has two components. One is the provisions of the Industrial Disputes Act. The other one is the principles emerged from the case law. When it comes, first I will deal with the provisions of the Industrial Disputes Act. So when it comes to industrial arbitration, the Industrial Disputes Act empowers the Commissioner and the Minister to refer industrial disputes to an industrial arbitrator. When it comes to the Minister, it is called compulsory arbitration. That means the Minister has power to refer an industrial dispute to an arbitrator even though the parties have not given their consent. It is called compulsory arbitration. When the dispute is referred to an industrial arbitrator, he gets a jurisdiction. Again, when it comes to his jurisdiction, he has jurisdiction with regard to the matter referred to the arbitrator, and also section 16, the proviso to section 16 provides that the arbitrator has jurisdiction to consider matters connected to the matter referred to him. And also again section 36 5 of the Industrial Disputes Act provides that fresh issues also could be raised with an industrial arbitrator. So when we combine all these provisions, so the arbitrator has very wide jurisdiction to hear industrial disputes, because the interpretation to the phrase industrial disputes itself is very broad. So once he gets a jurisdiction, he has to conduct an inquiry and hear the evidence tendered by the parties. Thereafter, he has to make just an equitable award. The award that is made by the industrial arbitrator binds the parties and becomes part of the contract of employment. So these are the provisions in the Industrial Disputes Act. So when it comes to these provisions, it provides a skeleton. So when it comes to the flesh and the blood, it is supplied by the principles evolved from case law. So here I am going to briefly discuss about the cases that has supplied the flesh and blood to the skeleton. One is when it comes to the powers of an arbitrator, there is a case law which says the minister has power to refer an industrial dispute to an arbitrator or not to refer an industrial dispute to an arbitrator. But I challenge that view, because when it comes to the minister, actually he has powers in trust. So he can't abuse the powers given by the legislation. If he abuses the powers given by the legislation, it may become violation of Article 12(1) of the Constitution. But it has not been judicially recognized yet. That is number one. Number two, when it comes to the minister, again, he can refer the disputes, but he has power to refer the dispute to an arbitrator, but he doesn't have power to revoke the dispute that he has referred. So there's a case law for that point. Again, when it comes to the cases, again, in this Ubali Newspapers Limited case, the Court of Appeal and also the Supreme Court held that the minister can't refer an industrial dispute which is pending before a labor tribunal. That also has been supplemented by the case law. Again, when it comes to the jurisdiction of an arbitrator that I want to skip. Again, when it comes to the powers of an industrial arbitrator, again, he can consider the the section 17 says the arbitrator has to consider the evidence tendered by the parties. But again, it is actually, as SRD Simba says, the arbitrator powers is not limited only to the evidence tendered by the parties as provided, because he cites another section from the Industrial Disputes Act, section 36(1)(b). According to section 36(1)(b), the arbitrator has power to require anyone to give evidence. So he says it's more than what is tendered by the parties. Again, when it comes to the duties of an arbitrator, he has a duty to act judicially, but he exercises his arbitral power, but still he has to act judicially. Then when it comes to the powers of an arbitrator, again he can create new rights and new duties. Again, this is also the crux of my argument in the paper. When it comes to the industrial arbitrator, whether he is bound by a contract of employment or not. But here actually I compare with a labor tribunal. Right? When it comes to a labor tribunal, the jurisdiction of a labor tribunal is very much limited. It is for termination of services and gratuity. But when it comes to the jurisdiction of an arbitrator, it is very wide, because in an industrial dispute is referred to an industrial arbitrator. So when it comes to industrial dispute, anything related to employment will come under industrial dispute. So when we compare with the labor tribunal, his jurisdiction is very wide. That is one thing. And also when it comes to the release from a labor tribunal, it is limited to reinstatement, compensation, gratuity and something like that. But when it comes to the release from an arbitrator, again it is very wide, because it is not limited to reinstatement or compensation. Again, when it comes to the Industrial Disputes Act, there is an important section. I would say, as our chairperson mentioned at the beginning, when it comes to contract of employment, it differs from other contracts. Because I would say section 31B4 of the Industrial Dispute Act is the most important section when it comes to labor law. Because if it is not there, then no need to have labor courts. The matters will go to the district courts, which are the civil courts. But when it comes to section 31B4, it comes under labor tribunals, not under arbitrator. So that means the legislature wanted to give that power only to the labor tribunal, not to the arbitrator. So section 31B4 says a labor tribunal is not fettered by a contract of employment when it makes an award with regard to the release. But we don't find any similar provision under the industrial arbitration. That is one thing. So then when we compare all these provisions, there is a doubt whether an industrial arbitrator is fettered by a contract of employment or not. So my point is, when it comes to this issue, an industrial arbitrator doesn't have the same power as it has been given to a labor tribunal. Because when it comes to a labor tribunal, section 31B4 applies, but when it comes to an industrial arbitrator, it doesn't apply. But again, there is another issue. Even though the industrial arbitrator is not bound by a contract of employment or bound by a contract of employment, the act is silent. Again, section 17 says industrial arbitrator has to make just and equitable award. So then my question is, if an industrial arbitrator is bound by a contract of employment, how he can make just and equitable award? So there are two conflicting issues. One is whether he is bound by the contract of employment. The other one is, if he is bound by the contract of employment, then how can he make just an equitable award? So my point is that an industrial arbitrator has to reconcile these two. Because when it comes to an industrial arbitrator, because of the nature of the jurisdiction and the nature of the release, and also when it comes to the legislative intention, because actually the section 31B4 doesn't come under industrial arbitration, it comes only under labor tribunal. So my point is, when it comes to an industrial arbitrator, he has very wide powers and discretion to decide whether to consider the contract of employment or not, or reject it. So when it comes to the industrial arbitrator, his powers are very broad. Actually, when it comes to the conclusion, that is why my conclusion, and also again, when it comes to an industrial arbitrator, he has to make just and equitable award. That is also very, very broad. Because when you say just and equitable award, it is there are so many principles evolved from that. But again, there certain principles say that it doesn't mean favoring one party. So that means industrial arbitrator should be fair by both parties, right? But when we compare all these things, so we can come to the conclusion, the wordings of the provisions of the Act underlying just and equitable concept, the judicial activism by the appellate court, and the combined effect of all expands the jurisdiction of an arbitrator and also confer very wide powers to an industrial arbitrator, subject to necessary safeguards, and also to perform his functions. And also when we compare with the powers of an industrial arbitrator with the powers of a civil arbitrator or arbitrator in commercial arbitrator, the powers and functions of an industrial arbitrator is very much wider than the powers of a civil arbitrator and civil arbitrator and commercial arbitrator. So that is my conclusion.